claimant.
Any other appearance?
Respectfully, my lord. Charles Ndaraki for the second and third defendants.
Any other appearance?
Respectfully, my lord, Uraola Obiebu for the fifth defendant.
Uraola what?
Obiebu.
Uraola.
O-B-I-E-G. Obiebu. O-B-I-E-B-B-U for the fifth defendant, my lord.
Any other appearance? Kneel for the fourth and sixth.
Yes, my lord.
Here is the judgment of the court. This action was commenced by a general form of complaint dated 22nd of June 2022 and amended on the 13th February 2023, wherein the claimant prayed the court for the following reliefs. 1. A declaration that the termination of a claimant's salary and entitlements per and from the 26th of November 2021 till date by the first, second, third, and fifth defendants is illegal, unlawful, and a gross abuse of governmental powers, as much as such null and void and of no effect. 2. A declaration that withholding of the claimant's secret and open files and fringe benefits, bonuses, and Christmas, Easter, and Salah gifts, and all other benefits howsoever called, incidental to her position as a staff of the Budget Office of the Federation by the second defendant is illegal, unlawful and a gross abuse by the second defendant is illegal, unlawful and a gross of governmental powers as such null and void and of no effect. 3. A declaration that the first defendant lacks the power to impose punishment of suspension of salary on the claimant save as stipulated by the Public Service Rule, which rule must be adhered to as expressly stipulated, as doing otherwise amounts to nullity. 4. An order of the Honorable Court compelling the defendants to pay the claimant all her salaries, entitlements, fringe benefits, bonuses, and all benefits howsoever called, incidental to her position as the staff of the Budget Office of the Federation, withheld by the defendants illegally and unlawfully, and amounting to 2,214,250 naira only. 5. An order of the Honorable Court compelling the second defendant to forthwith release the claimant's secret and open file to enable her proceed with the processing of her entitlement. 6. The sum of 500 million naira only as exemplary damages in favor of the claimant against the defendants, the latter having acted in bad faith. 7. General damages in the sum of 50 million naira in favor of the claimant and jointly and severally against the defendants for inconveniences suffered by her and caused by the defendants. And 8. Cost of this action at the discretion of the Honorable Court. It is the case of the claimant that she was an employee of the first and second defendants, She averred that while in service, she discharged her duties effectively and efficiently, but was unable to proceed on retirement due to the second defendant's personal vendetta against her for being upright and incorruptible, as she discovered a monumental corrupt practices by some staff of the third defendant, bordering on manipulation of budget proposals by MDAs, and upon reporting the issue to the second defendant, she discovered that the second defendant was complicit as well, and in a bid to frustrate her, the second defendant sent an SMS to one Emeka Obodo, the staff of the fifth defendant, to suspend her name from the IPPIS platform for the purpose of preventing her from receiving her salaries. She further averred that the second defendant, to further frustrate her, he also instructed his allies in the finance department to withhold and denied her all her entitlements and benefits due to her. She also stated that the second defendant, without any justification, caused her secret and open files domiciled with the budget office of the Federation Registry to be removed and kept in an unknown place. The fifth defendant filed its statement of defense, wherein it averred that the IPPIS is a dual function which deals with payroll, which it administers. It also deals with personnel, which is administered by the IPPIS unit domiciled in the Office of the Head of Civil Service of the Federation, and both aspects of the IPPIS system, although overlapped, are very separate and are controlled by two separate entities of the federal government. It was also averred that the said Emeka Obodo is neither an accountant nor a staff in the fifth defendant, but an IT staff of the Office of the Head of Civil Service of the Federation, and that employee salaries can be stopped by the personnel arm of the IPPIS unit of the Office of the Head of Civil Service, and stated further that the IPPIS unit of its office did not stop the payment of the claimant's salaries, and as such, she has no cause of action against the fifth defendant. The fourth defendant filed his statement of defense dated 25th August 2022, wherein it also averred that there has never been an employment relationship between him and the claimant, and as such, he is not indebted to the claimant whatsoever. Thus, she cannot claim damages against him, as the claimant did not disclose any reasonable cause of action against it. He averred that the subject matter of the claimant's action is on recovery of debt in a simple contract which is outside of the jurisdiction of this court. The second and third defendants, in response to the claimant's action, filed their joint statement of defense, which was replaced by a subsequent amended statement of defense filed on 6 December 2022, wherein they averred that claimant ceased to be a staff of the second defendant since 16th of March 2021 as a result of her redeployment to the Federal Ministry of Women Affairs. They continued that she was once petitioned on an allegation of corruption and also received salary even after absconding from service by failing to report to work at the Federal Ministry of Women Affairs. They equally alleged that claimant as a schedule officer padded the figure and submitted her own handwritten copy of the personnel budget to the Budget Collation Committee. They also averred that Kaduna Polytechnic had alleged in writing that she demanded bribe from the institution to perform her official function. They denied sending a text message to one Emeka Obodo or any other person in IPPIS to stop claimant's salary, as they do not have control over payment of salaries on the platform. They equally stated that they are obligated by law to stop the payment of certain welfare package incidental to the claimant's office, having ceased to be on its nominal role by reason of her deployment to the Federal Ministry of Women Affairs, and they are not responsible for payment of her salary, which is on the IPPIS platform, controlled and managed exclusively by the fifth defendant. They contended that the claimant did not formally request for her files, and that she does not require her secret files to process her National Housing Fund, pension, and other retirement benefits, as her information are within her personal knowledge and those of her pension funds administrator, and that the NHF and that of the NHF. They also averred in continuation that retirees are only entitled to record of service at the last place of assignment or at the pool where she was employed, and the proper place to process retirement benefits in the public service is the place of last posting or the pool. According to them, the claimant is not their employee, Rather, she was deployed to the second defendant from the pool of the first defendant, and that she was subsequently posted to another ministry, but she refused to proceed on her new posting, which is a serious misconduct under the public service rules punishable by dismissal. Whereof the second and third defendants' counterclaims against the claimant as follows. A declaration that the second and third defendants are not responsible for the payment to the claimant of any sum of money for welfare, item, or package, or any money whatsoever, including arrears of salary. However, so-called, the claimant having ceased to be on the nominal roll of the second defendant since March 2021 by reason of her deployment to the Federal Ministry of Women Affairs. B, a declaration that the claimant had exited the civil service since 16 March 2021 when she faced Ministry of Women Affairs and absconded from duty in consequence thereof, contrary to Rule 030301, paragraph B and M, Rule 030401C and E of the Public Service Rules 2008. C, a declaration that payment of salary and entitlements to the claimant from April 2021 after she absconded from the civil service to November 2021 when she received her last salary is irregular and illegal. D, an order directing the claimant to refund the sum of 1,155,680 naira 64 kobo erroneously paid and illegally received as salary from April 2021 to November 2021. The claimant having absconded from duty since 16 March 2021. E, an order directing the claimant to return official files and documents of the second defendant in her possession, which she refused to hand over upon her exit from the second defendant on the 16th March 2021. In the same vein, the first defendant files its defense, wherein it avowed that it has nothing against the claimant to warrant or preventing her from retiring from the civil service as a person can retire upon 35 years in service or attaining the age of 60, whichever is earlier. It stated that it is a calculated attempt of the claimant to hide under the auspices of refusing or neglecting to report to her current place of posting to resume her duties. It stressed that claimant is not on his nominal roll, as it is not responsible for the payment of her salary or any benefit whatsoever in the course of exercising her constitutional duties. It also averred that it is not indebted to the claimant in any amount whatsoever. On the 14th of February 2023, claimant opened her case by testifying for herself as CW. She adopted a written statement of the 9th of December 2022, 5th of December 2022, and 14th of February 2023. And equally tendered documents in evidence which were admitted and marked as Exhibit B to B8. She was also cross-examined by the defendants. Second and third defendants on 30th May called one Isha Kusani, testified for them as DW. Please mute yourself. Please mute your system. Mute your system. Please, whoever is online should mute. Very well. One Isha Kusani testified for the second and third defendants. He adopted his sworn deposition of 6th of December 2022 as his testimony. He tendered documents admitted and marked as Exhibit S to S4. Was equally cross-examined by learned claimant counsel. The first and fifth defendants were foreclosed from defending this action. In line with the provision of the rules of this court, all the defendants filed their final written addresses and have reduced pertinent portions of them into the body of this judgment. So I'll go straight to the decision of the court. Having given the case at hand an in-depth consideration, it is pertinent for me to first address the preliminary issues raised by the fourth defendant in his final written address, that the suit of the claimant discloses no reasonable cause of action against the fourth defendant, and that claimant's action can be sustained without joining the fourth defendant to the suit, and thus claimant's action is barred for misjoinder. Having regard to the constitutional provisions in section 6, subsection 6, paragraph B of the Constitution of Nigeria 1999 as amended, hereafter referred to as the Constitution, a cause of action is a question as to the civil rights and obligation of claimants found in the action to be determined by the court in favor of one party against the other party. See the case of Thomas and Ulufosoye, citation captured. Our law reports are replete with what reasonable cause of action is, and all those authorities are in agreement that a reasonable cause of action is an action with some chances of success. See the case of APC and Aguma, citation captured. SPDC Nigeria Limited versus XM Federal Limited and another, citation provided. Oshoboju, Oshoboja, and Amuda and others, citation captured. By all odds, the law has become ensconced that for an action to disclose a reasonable cause of action, it must set out the legal rights of the claimant and the obligation of the defendants. It must then go on to set out the facts constituting infraction of the claimant's legal right or failure of the defendant to fulfill his obligation in such a way that if there is no proper defense, claimant will succeed in the relief or remedy he seeks. See the case of CIL Risk and Asset Management Company Limited and Ekiti State, citation provided. The case of Ungwora and others, and Nwabweze and others, citation provided. The Apex Court's decision in the case of Renko Construction Company Limited and VP Industries Limited, citation provided. And finally, the notorious case on this subject, Igbe and Adifarasi, citation captured. The court, in considering whether or not there is a cause of action, has a duty to consider the averments of the claimant in the statement of facts. See the cases of Ross Jaws Company Nigeria Limited and another, and African Fair Publishers Limited and others, Huki and Fembo, citation provided. Ibrahim and Osim, citation captured. The court equally did not at this stage consider whether the claimant can succeed in the action or not. The court is only to consider whether there are some questions or issues fit for adjudication against the party. The court, in doing this, will consider the complaints of the claimant against the infraction of his right by the defendants as facts alone do not constitute cause of action. The court has no business in considering whether or not the defendant has a defense to the claimant's claim. I peruse the whole of the amended statement of facts of the claimant, and I find that the only averment of the claimant against the fourth defendant is contained in paragraph 5 of his statement of facts, where he averred that the fourth defendant is the chief law officer of the Federation, charged with the responsibility of advising the federal government of Nigeria on legal issues. There was nowhere in the whole of the 17 paragraphs of the amended statement of facts where claimant alleged any particular wrongdoing on the part of the fourth defendant, or that the fourth defendant breached his obligation in any way to give rise to the claimant's cause of action. May I also add that the mere fact that Section 151 of the Constitution creates the office of Attorney General of the Federation and makes him the chief law officer of the Federation does not mean that any person who may have a cause of action against any ministry, department, or agency of government will equally have a cause of action or his action disclosing a reasonable cause against the Attorney General of the Federation. Although the Apex Court in the case of Attorney General of Kano State and Attorney General of the Federation, citation captured, opined that the Attorney General of the Federation can be sued as a defendant in all civil matters in which a claim can properly be made against the federal government or any of its authorized agencies arising from any act or omission complained of. The pertinent question is, can a claim be properly made against the federal government in this case, especially since the relevant bodies have already been sued? The Attorney General of the Federation can be made a party to a case where the claim or complaint is directly against the federal government. In the instant suit, as raised in supra, a perusal of the claimant's statement of facts will show that there has been no complaint against the federal government directly to have the Attorney General to be joined to this action. In truth, the federal government was not directly concerned and no relief was specifically sought against it by the claimant in this case. In fact, reliefs 1 to 3 which are the principal reliefs in this case, were sought against other defendants, but they fought defendants. Claimant's action does not disclose the existence of any legal controversy between her and the the fourth defendant. It is settled law that though jurisdiction and reasonable cause of action are distinct, but they are interwoven. For without a reasonable cause of action, the court cannot have jurisdiction. This is so because where there is no reasonable cause of action, the court will be acting in vain if it proceeds to entertain such a suit against such a party. See the case of Amechi and Governor of Rivers State and other citation provided, Alhaji Sayina Adam and Hussein Zana Shaibu and other citation provided. It is thus clear that the claimant's action as contained in her amended statement of facts discloses no reasonable cause of action against the Attorney General. It is in the light of this that this court strikes out the name of the fourth defendant from this action. Next is the issue that arose in respect of the admissibility of some documents tendered by claimant during trial. On the 14th of February 2023, claimant sought to tender some documents which learned counsel for the first, second, third, and fifth defendants objected to, particularly the payslip and the circular, that is Exhibits B7 and B8 respectively. They objected to them on the ground that those documents are computer-generated evidence that ought to be accompanied by a certificate of compliance in line with Section 84 of the Evidence Act. Learned counsel on behalf of the claimant responded that truly the said exhibits are computer-generated evidence, and claimant is not the maker of either of them. He argued that claimant was issued with the said payslip by the fifth defendant, and that the circular was printed by the first defendant and circulated to all civil servants for posting. This court had admitted the documents and asked parties to address it in their final written addresses. I've taken a look at the final written addresses of parties and found that none of the parties addressed the court as ordered. Nevertheless, this court has an abiding duty to consider and rely on only admissible evidence, whether other parties object to them. Thus, where a court admits evidence which the law declares to be inadmissible, he has a duty to expunge it from the record at the final stage of writing its judgment. See the case of Ibrahim and Gelco, citation captured, Royok Nigeria Limited and AG and CJ Sokoto State and another citation provided. It is in the light of this that this court, notwithstanding the failure of parties to address it, will still consider the admissibility or otherwise of the said documents in law at this stage. Exhibit B7 is a payslip, while Exhibit B8 is a circular. The pertinent question that requires an answer here is, are these documents computer-generated evidence under Section 84 of the Evidence Act, requiring certification in line with the Evidence Act, or are they admissible under law? Before I proceed to answer, let me say that a court must not confine itself only to authorities cited by parties. It can, in an effort to improve its judgment, rely on authorities not cited by parties which are relevant to the determination of the issue in controversy. See the case of Adebanke and Ojelabi and others citation captured. The case of Orugbo and Una citation provided. Although none of the parties refers this court to the case of Attorney General of Federation versus Ane Gunwa, citation captured. This court take judicial notice of a decision wherein the Apex Court, per Oyewumi GSC at page 270 of the judgment, paragraphs F and G to H, held that a statement of account is a computer-generated evidence in line with Section 84 of the Evidence Act, because it is the algorithm stored in the database of a bank that produces the statement. The Apex Court in the above case also emphatically held that the mere fact that a document is typed using a computer does not make it a computer-generated evidence, but what makes a document against which the calculating or measuring accuracy of the computer is dependent upon or stands to be, and not ordinary documents printed out of the computer. Details of a statement of account because it's in the data
Hello? Hello?
Learned Counsel, I'm sorry, I had issues with my internet, so I have reconnected. I'll continue from where I stopped.
Okay, my lord.
I do not lose sight of the fact that upon a close perusal, one will find that Exhibit B8 is a photocopy of a circular, which is secondary evidence. Although some of the parties raised this in their objection. Section 102 of the Evidence Act defines public documents as documents forming the official acts or record of the official acts of A, the sovereign authority, B, official bodies and tribunals, C, of public officers, legislative, judicial, and executive, whether of Nigeria or elsewhere, and public records kept in Nigeria, private documents. See also the case of Eniloloba and NPDC and other citation captured. Exhibit B8, no doubt, qualifies as public document on which the only admissible secondary evidence is a certified true copy. See the case of Udo and the State, Aromalara and Agoro, Kubo and another, and Dixon and others, Araka and Egues, all citation captured. The photocopy of the circular is secondary evidence and ought to be certified in line with the Evidence Act, and thus Exhibit B8 is inadmissible. In view of the foregoing, I find both Exhibit B7 and B8 being Court Registrar. The internet is on, so I don't know why it's going on and off. Maybe you should let the IT personnel check it, but it's back now. So let me continue. Both Exhibit B7 and B8 being inadmissible documents are expunged from the record at this stage. Now to the substance or gravamen of this action. Let me now frame these two issues, the determination of which I firmly believe would do justice to parties in this case. Viz. 1, whether claimant has proven a case to be entitled to the relief sought in the main claim. And 2, whether the counterclaim of the second and third defendants succeeds. To issue 1 frame, let me brevar mono deal with the submission of learned claimant counsel in his final written address to the competence of the statement of defense or counterclaim of the second and third defendants on the ground that they offend the provisions of the practice direction of this court. According to counsel, amended statement of defense of the second and third defendants did not comply with the provision of rules 3, 2, and E and 3B, sub 1 and 2 of the rules of this court, the practice direction of this court 2022 as regards marking the exhibit and documents both in the statement of defense and witness deposition, and as such ought to be struck out as prescribed in the practice direction. The position of the law is settled that statement of defense filed in contravention of the rules, though filed irregularly, is not a nullity but avoidable document, which remains a valid document until it is set aside. The courts have rationalized their decision on the fact that the court, in the exercise of its primary duty to do justice, can invoke its rather extensive discretionary powers and look at the invalid but not void statement of defense, and then do what the justice of that particular case demands. Thus, once a defense has been filed, the court must consider it before delivering its judgment and cannot turn a blind eye to it, even if it was filed irregularly. See the case of Oke and Tsuli and another citation captured, Mana and PDP citation captured, Nishizawa Limited and Dethwani citation provided. At any rate, it does not lie in the mouth of the claimant at this stage to be objecting to the competence of the amended joint statement of defense and counterclaim of the second and third defendants. It is noteworthy that claimant had, by way of a reply, responded to the said processes which counsel on her behalf want this court to discountenance. Thus, she has joined issues on the said statement of defense and did not raise it at any stage of the proceedings till her final written address. It is too late in the day for her to raise such. In the case of Akumechiel and BCC Limited citation provided, Muntaka Kumasi JC as it then was, while considering the effect of failure to quickly object to an irregular statement of defense held as I quote, finally, is the question whether or not the trial judge was right to rely on the proposed statement of defense not yet filed. My answer is that it is too late in the day to raise such matters. Parties had contested the case at the lower court on the basis that the statement of defense was validly filed. The failure of the defendants to file their statement of defense within 14 days granted them by the court was a mere irregularity. It did not vitiate the statement of defense actually before the court. If plaintiff or appellant had felt dissatisfied with the situation, he should have raised the matter before the commencement of hearing. Having allowed the trial to commence and end on the mutual assumption that there was before the court a statement of defense properly filed, the appellant could no longer turn around in his address as did not ask that the statement of defense before the court should be discountenanced. He must be deemed to have waived any irregularity arising from the filing of the statement of defense, unquote. See also the case of Koloko and another versus Nkwonta citation provided. In fact, learned counsel even cross-examined DW on his written depositions, which accompanied the said statement of defense and which process he wants the court to strike out. The claimant, having joined issues with the said statement of defense, cannot be allowed at this stage to challenge the competence of same, as that would amount to blow hot and cold or approbating and reprobating, which is an anathema in law. Also, having not raised it earlier until the final written address had waived her right to object to the statement of defense, even if defective, by not raising the issue earlier, and even going on to respond to same by filing a reply. The submission of counsel in the realm of an The submission of counsel is in the realm of an afterthought, which this court will not allow. The said objection is therefore discountenance. Let me first say that claimant had filed an originating process along with a statement of facts and other processes. The defendants responded to claimant's action by filing their respective defense. Subsequently, claimant amended her originating process together with her statement of facts and other processes. However, defendants did not file a consequential amendment to their statement of defense, which they had filed before claimant amended her process with the leave of court. It is Greenhorn law that upon an amendment of a statement of claim, herein called the statement of facts, the defendant is at liberty to amend his statement of defense without leave of court, insofar only as is necessary to meet the facts introduced by the amendment. However, where a defendant fails to amend his defense and his original defense thereby stands as a defense to the amended statement of claim, parties are brought to an issue on the amended statement of facts. Thus, a defendant is not obliged to file a consequential amendment to an amended statement of claim or fact, especially if he feels his statement of defense is sufficient to answer the facts, including the new ones introduced in the amended statement of facts. See the case of Afemike and others and Stanbic IBTC Bank citation provided. The case of Mobile Oil Nigeria Limited versus IAL, the Deceased Incorporated citation provided. Since the defendants did not file any consequential amendment to their respective defenses before the court, their statement of defense before this court, in this case, to the original action are deemed to be their defense to this action, I so hold. Now, it is the claimant's contention that the second defendant unlawfully withheld her salaries and other entitlements. The first and fifth defendants in response filed their statement of defense and a witness statement on oath in support, but the statements were never adopted before this court because only the second and third defendants called a witness in this case. It is thus clear that the statement of defense of the first and fifth defendants are without witness statement in support. Unquestionably, the law is ensconced that pleadings is not synonymous with evidence required to prove that fact, as pleadings do not constitute evidence, but are to prove by evidence. See Sokoto and INEC citation captured, Ayola and Pedro citation provided. Pleadings do not have a hand and a mouth with which to speak. They only speak through the witness who adopts his witness statement on oath in support of a pleading. In the case of Sokoto and INEC Supra, the Apex Court held that front-loaded deposition on oath of a witness in support of his pleadings constitutes his evidence in chief in the proceeding. The court went further at page 601, paragraphs B to C, to hold that pleadings do not have attributes, so they need human beings with the automation of the brain to express its content in open court. Thus, where the contents of pleadings are not activated in open court through a human being who is expected to adopt the written position in open court, then the pleadings are deemed moribund. The above was what the witness statement on oath of the first and fifth defendants were supposed to do if they had called the witness. Excuse me, let me quickly get them to on the gen. Just a minute. It is noteworthy that regardless of the fact that the first and fifth defendants did not call any witness in support of their pleadings, they each cross-examined the claimant on the 14th of February 2023. The law is on a firmer terror that evidence elicited from a party or is witness under cross-examination which goes to support the case of a party, cross-examining constitutes evidence in support of the case or defense of that party. If at the end of the day, the party cross-examining decides not to call any witness, he can rely on the evidence elicited from cross-examination in establishing his case or defense. In such a case, you cannot say that the party calls no evidence in support of his case or defense. One may, however, say that the party called no witness in support of his case or defense, not evidence, although the evidence so elicited under cross-examination must be on facts pleaded by the concerned party. See the cases of Adama and others and Kogi State House of Assembly and others citation captured. Akomalafe and Guardian Press Limited citation provided. As such, any evidence elicited from claimant under cross-examination by the first and fifth defendants, which is on fact pleaded by them and seems to support their pleadings, will be deemed by this court as evidence in support of their case. I so find and hold. Having settled the above, it is the contention of the claimant that her salary and other entitlements were unlawfully stopped by the second defendant, and that the second defendant had directed one Emeka Obodo in the IPPIS platform to stop her salary. The second and third defendants, in response by their amended joint defense, denied sending a text message to the said Emeka Obodo, as they do not have control of payment of salaries on the platform. To the second defendant, the claimant had been posted to the Federal Ministry of Women Affairs and they could not continue the payment of salaries or other welfare packages to claimants since she is no longer on the nominal roll of the second defendant, having been posted out. Read a letter dated 16 March 2021. The posting instruction, which is part of the documents marked as with S. Claimant, in response to the above averment by her reply to same, contended that she was not posted out of the Budget Office of the Federation and that she may remain the staff of the Budget Office until 25th November 2021, when the event that led to the dispute in this case arose. She maintained further that she did not cease to be a staff of the Budget Office as from 16 March 2021, and she remained a staff till her retirement, and she even filed filled her retirement documents in the said office, and that she's entitled to payments, benefit, financial, and otherwise. Now, the second and third defendants are alleging that claimant ceased to be their staff since she was posted out on the 16th of March 2021, when she's saying that she was only posted out in November 2021 via the circular. She denied receiving the letter of posting of 16 March 2021, which is part of Exhibit S. I bear in mind the testimony of claimant in paragraph 8 of her additional statement on oath at page 479 of the record, to the effect that she was not aware of any posting deploying her to the Federal Ministry of Women Affairs. I've perused Exhibits B5, S, S3, and S4. I find from Exhibit S that by letter dated 16 March 2021, claimant was indeed posted out of the Budget Office of the Federation by the first defendant, who initially posted her to the second defendant office from his own office, and which fact claimant had admitted under cross-examination by learned counsel for the second and third defendants on the 14th February 2023, that she was indeed deployed from the pool of the first defendant as principal executive officer, and which fact is corroborated by the content of posting order dated 21st of April 2004, which is part of the document marked as Exhibit S. It is of note that claimant denied receiving the said posting letter, posting her out of the office of the second and third defendants to the Federal Ministry of Women Affairs. I find from Exhibit S4 that a written complaint was made against claimant by the second defendant, wherein it was stated that she refused to collect the posting letter. I bear in mind also that claimant was first issued a preliminary letter querying why she has not complied with the posting letter, and in her response to the query as contained as with B5, tendered by her, said she was not aware of any such posting. In fact, even in her said response dated 21st of April 2021, on which there is a stamp of both the first and second defendants, she maintained that she would not obey the said posting if there was. She wrote, and I quote, paragraph 4 of the letter, "If truly there exists a posting moving me out of the budget office, which was kept away from me as I have not seen any, then there is a grand design by the headship of the budget office to get back at me for standing against corrupt and abuse of office." Paragraph 5. "Should your office not find reason to reverse the present course, I shall in the coming weeks appeal to the Presidency and the National Assembly. I'm being singled out for the alleged posting because I petitioned the head of service bringing its attention to corruption, abuse of office in Budget Office of the Federation, including refusal to honor posting by persons of Agatha Tokwe Ajayi and Alice Ajegunle, whom have been posted out severally, but remained in the Budget Office perpetuating corruption." Paragraph 9. "I'm also aware of the consequence of refusing to honor a posting, but this present alleged posting is one done in bad faith, and I know that my allegiance to the federal government of Nigeria and the Constitution to expose crime and corruption superseded my allegiance to the provisions of the Civil Service Rules," unquote. In the same vein, upon the scrutiny of Exhibit B5 as tendered by claimant, she was issued another query by the first defendant almost a month after she received the first one, on the same issue regarding her refusal to comply with her posting to the Federal Ministry of Women Affairs, as seen in preliminary letter dated 17th May 2021, and which query claimant responded to vid a response dated the same 17th May 2021, wherein she again maintained her stance above as contained in the first preliminary letter. Now the question is, assuming claimant before these preliminary letters was not aware of her posting initially, are the two subsequent preliminary letters not enough to intimate her of her posting, which she ought to have complied with forthwith? Instead, she was being unusually stubborn in her stance of not obeying the said posting. If I may ask, is she not a staff of the first defendant, that is the office, the head of service? And was it not the same first defendant that posted her to the Budget Office of the Federation in 2004? Now, if after spending almost 17 years in her place of posting at the Budget Office, her employer decides to post her out, should there be any problem, especially since the said budget office is not her place of employment, but merely a place of posting? It is the prerogative of the first defendant to either leave her or post her out, and such prerogative cannot be questioned by the court, as was the position of the court in the case of Shell Petroleum Development Company Limited and Inwaka citation captured. The right of an employer to post its employee wherever is desirable cannot be equally questioned by the court. Claimant had alleged in paragraph 11 of her additional written statement on oath, which she already adopted as her oral testimony, that she was only posted out by a circular in November 2021. I'm also mindful of the submission of her counsel at paragraph 0.7.4 of his final written address that the court should jettison Exhibit S1 and find that the only posting instruction is that of 25th November 2021, which she admitted receiving. I've discountenanced the circular which she relied on as evidence in proof of the fact that there was a posting instruction to her on 25th of November 2021, and I've expounded same earlier in this judgment. Since the said circular, which allegedly just posted her out on 25th November 2021, recorded in writing, oral evidence of its contents cannot be given because same does not fall within the category of documents in which secondary evidence may be given of its content under Section 89 of the Evidence Act. See the cases of Sahara Energy and Oyebola citation captured, Guduzu versus Abubakar citation provided, Lawoye and Bello citation captured. Thus, the evidence of claimant that she was only just posted out on November 25, 2021 is of no evidential value and thus is countenanced. In fact, I must not forget to point out that claimant, even during cross-examination by learned defense counsel for second and third defendants, stated categorically that she even did not obey the said posting, which she referred to in her testimony because she was preparing for her retirement in 3 months. It is of note that while claimant was only being cross-examined, was also being cross-examined by learned counsel for the first defendant, she confirmed the fact that she did not obey the said posting because she was retiring. And when further asked if in her 35 years in service, she was aware of any circular that permits officers who are retiring to refuse to proceed or accept posting, she answered in the affirmative that, I quote, "Yes, if you are retiring in less than 1 month," unquote. I bear in mind the testimony of the claimant who had earlier stated while she was being cross-examined by the second and third defendants that she did not obey the posting because she was preparing for her retirement in 3 months, is now the same person saying that a circular exists which only permits an officer retiring in less than 1 month to refuse posting. The same circular which allegedly permits such has not been placed before this court. Again, if her assertions under cross-examination are even anything to go by, claimant was supposed to proceed on the posting since she was only retiring in 3 months, and the alleged circular only permits someone who has less than 1 month to retire, as she said. In fact, by claimant's uncontroverted evidence in this case, she was due for retirement on 1st of April 2022, which means that even as at the said November date, she still had 4 months and some days to her retirement. In fact, it shows that she had not even proceeded on the mandatory 3 months terminal retirement leave in the public service, which fact is corroborated by the evidence of DW under cross-examination by claimant counsel, wherein he answered emphatically that claimant was due for retirement on the 1st of April 2022 and is supposed to proceed on her 3 months terminal leave in January 2022. From the foregoing, the acts of a claimant points to only one direction, and which is that claimant has grown too big than the authorities, that is, her employer. The only honorable option for her, since she was not willing to proceed on the posting as requested, is for her to honorably exit the service. This to me is a clear case of willful disobedience to lawful order and insubordination on the part of the claimant, contrary to Rule 030301, paragraph B of the Public Service Rules. In the case of Sule and Nigeria Cotton Board, citation captured, the legal effect of disobedience and insubordination was aptly captured by the Supreme Court per Obaseki GSC, does, and I quote, When a servant grows too big to obey his master, the honorable course open to him is to resign in order to avoid unpleasant consequences should an occasion which calls for obedience be serviced with disobedience. Both common law and statute law book in both common law and statute law book, no disobedience of lawful order from any servant, high or low, big or small. Such conduct normally and usually attracts the penalty of summary dismissal. Disobedience ranks as one of the worst forms of conduct in any establishment. When, therefore, the plaintiff embarked on a course of disobedience of lawful orders, it must have been the Christian spirit that worked on the board to persuade the board not to visit the conduct with the penalty of dismissal. The fact that in addition to the disobedience, there is the insubordination helps to emphasize the magnanimity of the board and the sacrifice it made in conferring full retirement benefits on the plaintiff. It would have been otherwise if the plaintiff had committed no act of misconduct, unquote. Okuta GSC of blessed memory, on his own part in the same case, asserted thus, and I quote, "I cannot conceive any terms and conditions of service, be it the civil service condition or the boards, that will legalize disobedience to lawful order and instruction or tolerate insubordination," unquote. This position was reiterated by the Apex Court in the case of University of Calabar and SCN citation provided. The court will not encourage an employee who willfully, under whatever guise, disobeys lawful instructions. Even if claimant had any reservations about her posting, she was supposed to obey the last command first before complaining. Leonard Claimant's counsel, in his final written address, made a heavy weight of the fact that claimant's employment is statutory as it is governed by public service rules, and as such, employment must only be dealt with in line with the public service rules. By the decision of the Supreme Court per Echo GSC, now retired, in the case of Avery and IPOS, citation captured, the fact that an employee's contract is clothed with statutory flavor does not empower him to misconduct himself. Thus, the mere fact that claimant's employment is clothed with statutory flavor or governed by the public service rules does not vest in her the right to misconduct or grow bigger wings than her employer, as she did in this instance. Needful to say here that her letter of transfer, that is Exhibit S, did in fact reference the consequence of her refusal to proceed on transfer as a misconduct, which is in contravention of Rule 030301, paragraph B of the PSR. Besides, claimant in this case, who by her testimony wants the court to believe that she was blameless and incorruptible, and that it was in her quest for a corrupt-free office that she was witch-hunted, has put her character on the line, and which case gives the defendant right to tender Exhibit S1, which shows that while she was a scheduled officer in charge of Kaduna Polytechnic, she did request for gratification to do her job. Although claimant during cross-examination by the second and third defendants' counsel initially denying that there was a petition against her as contained in Exhibit S, when she was referred to paragraph B of her reply, she owned up to the fact that there was a petition. Claimant oral evidence in paragraph 4 of her statement on oath that she did not demand any bribe cannot discredit clear contents of Exhibit S1. See the case of Ayori Indian Kuforiji citation captured, Oilfield Transnational Investment Limited and FVN citation provided, and the case of Skybank PLC and Akinpelu Supra. The above evidence in itself has shown that claimant is someone of questionable character and ought to even be posted out of the said National Budget Office. Also, claimant had stated in her pleadings and paragraph 10 of her deposition in support of her statement of fact that it was the second defendant that instructed Wanemaker Obodo, a staff of the fifth defendant, by a text message to suspend her from the IPPIS payment platform in order to prevent her from receiving her salaries. The fifth defendant had denied that any Emeka Obodo was its staff, and stated further that the said Emeka Obodo is an information technology staff of the first defendant. The fifth defendant cross-examined claimant on her testimony that Emeka Obodo was his staff. When claimant was cross-examined by counsel for the fifth defendant, she recanted her testimony that the alleged Emeka Obodo was not a staff of the fifth defendant, but that of the first defendant. She equally did not tender evidence of the alleged text message sent to Emeka Obodo by the second defendant to stop her salary. This shows that claimant's testimony above could not be believed. Claimant had also maintained that her entitlements by way of bonuses and other benefits, which amounts to the sum of 1,489,250 naira, were not paid. She gave particulars of the said sum in her amended statement of facts. The second and third defendants contended that they are obligated by law to stop the payment of certain welfare package incidental to the claimant's office having ceased to be on its nominal roll by reason of her deployment to the Federal Ministry of Women Affairs. And they are not responsible for the payment of a salary which is on the IPPIS platform controlled and managed exclusively by the fifth defendant. First, claimant has the burden to prove her entitlement to the said bonuses and benefits, and proof of entitlement by law is often by reference to an instrument which grants same. See the case of the decision of this court, in the case of Suraju Rufai and Bureau of Public Enterprise and Others, suit number NICN/LA/18/2013, delivered on 4th of June 2018, case of Mohammed Dunguz and others versus ENL Consortium Limited, citation captured. Claimant has not placed any document before this court showing her entitlements to the said fringe benefits. Besides, as reason supra, she has not shown that she worked for the second and third defendants beyond March 16, 2021. When she was posted to the Ministry of Women Affairs, which posting she failed to comply with. Be that as it may, it is a matter of common sense and law that a person cannot be expected to pay someone who does not work for him. Claimant by her process is saying that she was not paid from December 21 to April 2022 when she retired. The moment claimant was posted out of the office of the second and third defendants and she refused to comply with the posting, she stopped being entitled to salaries from them because she was no longer their staff. Defendants were even magnanimous by paying her from that said March 2021 when she was initially posted to November 2021, even though she stopped being their staff. I did not travel to Beijing, India, to know that claimant's conduct by her refusal to obey the posting will be termed misconduct anywhere in the world, and which act this court will not encourage. The said act ordinarily should have warranted or attracted disciplinary proceedings with a view to dismissal under the public service rules. Claimant has not shown that she worked for the second and third defendants within the period wherein she's asking for her salaries to be paid. It is rudimentary law, which I need not cite an authority for, that a person cannot be paid for work not done. I think every employee who wishes to keep his job or wants to be paid for services rendered must bear in mind that he or she cannot disobey lawful instructions and expect a pat on the back from this court, that is the National Industrial Court of Nigeria. More so, it is a fact that has gained notoriety in this country that payment of salaries of civil servants is done by the IPPIS platform under the fifth defendant and not the place of assignment. Thus, even if claimant had worked for the second and third defendants, which obviously is not the case here, it is the fifth defendant that had the obligation to pay her salaries and not the second and third defendants. In the case of Boye Industries Limited and Showa citation captured, the Apex Court per Eco GSC retired held inter alia that the court should be agitated to invoke the maxim of equity. He who comes to court to seek justice must come with clean hands and conscience in applicable circumstances. In the same vein, the late erudite jurist Pat Acholono Jesse, in the case of Kwajafa and Bank of the North, citation provided, equally held us, and I quote, "It is not justice meted to someone who does not deserve it when that person craving for it has his hand soiled, blemished, and besmirched." Citation, unquote. It is thus clear that a party who has had his hands soiled cannot be seeking for justice. It will not accord with common sense and equity To sustain the position of claimant that she is entitled to salaries and other entitlements even when she disobeyed the simple lawful order of posting and has not shown by any credible evidence that she worked during those periods. Claimant's action is nothing short of gold digging, and as such, is nothing but a gold digger. In the case of Oshine Bank International Limited and Chitex Industries Limited citation captured, Fabi JC as in then was, later JSC and now retired, unmistakably stated, and I quote, "Gold diggers should keep off from courts of law as well as that of equity, and court should always be wary of gold diggers and not allow the institution to be used unwittingly as instrument for attaining their nefarious and mundane desires. A party who is entitled to a pound of flesh should not be given 100 of same, as a judge is not a Father Christmas," unquote. Claimant in this case also alleged that the second defendant, without any justification, caused a secret and open files domiciled with the Budget Office of the Federation Registry to be removed and kept in an unknown place. Second and third defendants contended that claimant did not formally request for same, and that she does not even require her secret files to process her National Housing Fund, pension, and other retirement benefits, as her information are within her personal knowledge and those of her pension fund administrators and the NHF, as it has never been the practice in the public service for the employer to receive original documents of employees. They also averred in continuation that retirees are only entitled to record of service at the last place of assignment or at the pool where she was employed, and the proper place to process retirement benefits in the public service is the place of last posting or the pool. Claimant, in response by reply, stated that she requires her secret file for proper documentation of her retirement process, that her last place of assignment was the Budget Office, and that she had demanded for same but was not given. Claimant has the burden to prove her above assertion as to the denial of files for processing her retirement benefits. The above assertion of the second and third defendants concerning claimant's file were reiterated in written deposition of DW, which forms part of his oral evidence in this case, particularly at paragraphs 20 to 22 thereof at page 301 of the record. Learned Claimant Counsel never cross-examined DW on these material facts in his cross-examination. The effect of failure to cross-examine a witness on the germane issue is a tacit acceptance of the truth of the evidence of the witness. See the cases of Andraus and another, and Masha, citation captured Abiodun and the state, citation provided Amadi and Nwosu. The testimony of DW as regards the issue of claimant's file and the processing of her retirement benefit, which supports the averment of the second and third defendants having not been challenged by the claimant under cross-examination, is taken as true. Thus, this court cannot fault the second and third defendants in any way. I must say in conclusion that if there is any case or action that is bereft of any substance or merit, this is certainly one of such. Claimant has sown the wind of disobedience, impunity, and insubordination, and thus must reap the whirlwind of denial of her salaries. With utmost respect to learned claimant counsel, he has only dissipated energy to raise a dust where there is no need for one, and pursuing this action in the light of the conduct of his client, which is even evident from the exhibit tendered by her, is like weeping a dead horse. Miracles do not happen in courtrooms, especially in our adversarial system of law. Once a case is bad, it has no any other name, but it is bad. It cannot be rescued by the most learned of lawyers. Indeed, claimant's grouse as regards non-payment of her entitlements and salaries is a tissue of hypocrisy, humbug that makes a loud, frivolous fuss over nothing. Since her main reliefs have failed, it is also a matter of common sense and law that her other reliefs for damages cannot be sustained. It is in view of the foregoing that this court finds that claimant's reliefs 1 to 7 fail. Thus, a case fails in its entirety, and same is hereby dismissed. On issue 2, which borders on the counterclaim of the second and third defendants, I must say at this stage that I noticed that the second and third defendants in their amended statement of defense counterclaim for some reliefs against the claimant without pleading their counterclaim as seen at page 291 of the record. This is rather strange and irregular. All I need to say is to emphasize that the provisions are express and clear as crystal, leaving no room for suppositions in what was provided for in the rules of this court as regards the statement of defense and counterclaim, particularly of the 15 Rule 2, Sub-Rule 4 of the rules of this court, which states thus, and I quote, "Where a defendant is served with an originating process as required by Order 3 of the rules of this court, the defendant shall expressly state in details in the defendant's statement of defense, A, whether the defendant admits the claim in whole or in part. B, if the defendant admits the claim in part, the defendant shall state what part of the claim is admitted and how the defendant intends to pay the part or amount admitted. And C, if the defendant has a counterclaim or a set-off against the claim, the defendant shall clearly state this in the defense and proceed to plead the defendant's counterclaim, which shall be treated as claim," unquote. The above provision of the rules are clear as regards the statement of defense and counterclaim. What same should contain, no more, no less, as they admit of no importation of any word from outside. By all odds, it is Abecedarian law that a counterclaim is an independent and separate action which is governed by the same rule of pleadings as the main claim. See Olaiwola, Minister FCT, and other citation provided. Atibayala Savings and Loans Limited and Suberian, and another citation provided. Ejikan Obiegbunam and another citation provided. Of Folai and Aria and other citation captured. A counterclaim is a defense which enables the defendant to enforce the claim against the claimant as effectually as an independent action. See DAM and NLPC Pension Fund Administrators and another citation captured. Thus, a defendant in an action who alleges that he has any claim or entitled to any relief against the claimant in an action may, instead of bringing a separate action, make a counterclaim in respect of that matter. He does so by adding a counterclaim to his defense and set out in his counterclaim the facts supporting the reliefs he is claiming. Counterclaim must be distinctly proved, as it is an independent action for all intent and purposes. It is therefore important that the facts in support of a counterclaim be properly pleaded like those in the statement of claim or statement of facts. It is capable of being determined on its merit, even where the main claim is struck out or dismissed. Whatever happens to the claim of the claimant, whatever happens to the claim of the claimant does not affect the counterclaim. The trial success of the counterclaim does not depend on the success or failure of the original suit. Pleadings are filed and evidence led to substantiate the claim of the defendant in his counterclaim. If any of the facts on which the counterclaim is founded have already been stated in the defense to the substantive or main action, then those facts need not be restated in the counterclaim, but have to be incorporated by reference in the counterclaim. In such instance, one usually finds the defendant stating in one paragraph of the counterclaim that he repeats paragraph so, this to that of the statement of defense in his counterclaim, after which he goes on to seek the reliefs he wants to seek. Such a defendant is at liberty to aver additional or further facts contained in the statement of defense that have been incorporated by reference into the counterclaim. On the other hand, you find the counterclaimant reproducing all the averments in the statement of defense as the averments he relies to sustain the counterclaim instead of incorporating the same by reference. As such, where the facts which are contained in the statement of defense are the same facts needed to prove the counterclaim, a defendant either incorporates the facts in the statement of defense into the counterclaim by reference, or he takes the pain to reproduce them one after the other in his counterclaim before going ahead to seek his reliefs in the counterclaim. See the case of Zumi and Okonkwo and another citation provided. It is thus clear that where the same facts which are already stated in the statement of defense are relied on in proof of counterclaim, the law allows the defendant to either incorporate his defense into the counterclaim by reference or to restate those facts already stated in the statement of defense in the counterclaim. All I'm trying to put across here is that there must be averments in the counterclaim, and that where the same facts which are already stated in the statement of defense are the same which the defendant intends to use to prove his counterclaim, the law allows him to either incorporate the averments in the statement of defense into the counterclaim by reference or to restate those facts already stated in the statement of defense one by one in the counterclaim. In the instant case, the second and third defendants, however, failed either to incorporate the facts in the statement of defense by reference into their counterclaim or restate the facts which are in the statement of defense but which support their counterclaim. They merely averred facts in their statement of defense and went ahead to counterclaim for release without distinctively averring and the facts in their counterclaim which they need to support the release they sought in their counterclaim by way of counterclaim distinctively. They need to be reminded that a counterclaim is not part of a statement of defense, but an independent action. But for convenience, it is filed along with the statement of defense, so it needs its own averments to succeed. In fact, the second and third defendants are thus left with bare reliefs in their counterclaim. It is thus firmly settled that reliefs do not constitute part of facts pleaded, and as such, a relief must be based on substantive averment of facts in the body of pleadings. See the decision of the Supreme Court in the case of Trade Bank PLC and Pharmatech Limited, citation captured. Since the second and third defendants' counterclaimants have not pleaded facts in their counterclaim in support of the reliefs they are counterclaiming, this court finds that their counterclaim is barren without facts which in turn will affect the relief sought in their counterclaim. They are left with barren reliefs in the counterclaim, and this will have a caustic effect on their counterclaim. Second and third defendants' counterclaimants have left their reliefs in their counterclaim unattended to by not pleading facts in support in their counterclaim, which is a separate action. The effect of such is that they have abandoned the reliefs. The apex court per order GSC now retired in the case of Society, Big, SA, and others versus Shazin Industries Limited, citation captured, consider the effect of abandoning reliefs, thus I quote, "A need to reiterate a rather tried point is that a party or counsel on his behalf has to be up and doing in canvassing what relief they seek. Therefore, a party must move the court on each prayer or relief, and any of such prayer or prayers that are left unattended will be taken by the court as abandoned. The court cannot on its own get into such an abandoned relief or grant or even make comments thereon. This is because the duty of court is streamlined and must be carried out with the jurisdiction to entertain whatever has been presented before him or assumed to have been so presented. Therefore, what the appellants hope for from the court stemmed from their attempt to clothe the court with the garb of famed or fabled, quote unquote, Father Christmas or philanthropic organization which attends to the needs of whoever, even if not requested for, unquote. It is in the light of the above that this court deems the relief in the counterclaim of the second and third defendants' counterclaimants as abandoned, having not been supported by corresponding averments in the counterclaim, which is a separate action from the main suit. Thus, the counterclaim fails for abandonment. I so hold. In sum, I declare an order as follows. 1, that the name of a fourth defendant is struck out. 2, the case of a claimant fails in its entirety and is hereby dismissed. And 3, the relief sought in the counterclaim equally fail and equally dismissed. Judgment is entered accordingly, no order as to cost. parties are entitled to copies of this judgment. So you can always pick one on Monday. Court registrar.
Thank you very much, my lord, for an order justice. We are very grateful.
Very well.
We appreciate my lord's industry in this matter. We are much obliged, my lord.
Very well.
My Lord, we are just grateful for the considered judgment of the court. We are grateful.
Very well. Court registrar, call the second case. Court registrar. Call the second case.
Yes, my lord. Case number NICN/ABJ/107/2023 between Comrade Habib Wisman to Comrade Monday Alonge and National Theatre and the National Troop of Nigeria Board. 2. The Honorable Minister of Information and Culture. And 3. Professor Sonny NSC Ododo.
Who is in court? Is any of the parties in court?
Very well, my lord.
Is any of the parties in court?
Yes.
Not at all, my lord. Not at all, my lord.
Parties absent.
Yes, my lord.
Appearances.
With greater respect, my noble lord, so I will verify my name and my whole appearance is all the same. May my lord be pleased.
I can't see you, Mr. Audu.
Yes, my lord. My lord, I'm here, my lord.
Very well.
Thank you very much, my lord.
For the claimant.
Yes, for the claimant, my lord.
Any other appearance?
May my lord be pleased. May my lord be pleased. All genius. My humble appearance is for defendants.
Mr. Nelson, where is your wig and where is your
May
wig?
Lord, it was even, may Lord, it was in the court. I am sorry, it was in the court. I asked Adam. He said, I also have room. I'm very sorry. I left him to come back in my office. I'm sorry, my Lord. For my intercession.
Very well. Have you filed your final addresses?
Very well, my Lord. I have filed.
When was it filed?
Filed on the 7th day of February, my Lord.
Court registrar, mute your system. I don't want to hear any noise at the background, please.
My Lord, I'm asking the court registrar's phone because I'm having issues with internet. That was why I had to rush down from the office to the open court, my Lord.
Okay, no problem, but you can mute yourself. If you're addressing the court, then you are muted.
Okay, my Lord.
Mr. Oji, you said you have filed the defendant's final written address.
Very well, my Lord.
When was it filed?
Filed on the 7th day of February and served on that same date.
Did you file within time?
Sorry, my lord.
Did you file within time?
Very well, my lord. I filed on Tuesday.
My question was, when you filed on Tuesday, did you file within the stipulated 21 days given to you, or you filed outside of the 21 days? Which means you need to file a motion to regularize it.
Very well, my lord. Very well, my lord.
You haven't answered my question, Mr. Oji.
No, my lord, I did not file within the 21 days. Then there is need for a motion to regularize it.
So did you file the motion to regularize?
I did not file the motion to regularize. I took the hint from the court that I should file within 7 days, within the days allowed in court. Maybe we go back and bring a motion to regularize it, my lord.
Mr. Audu.
Yes, my lord. Yes, my lord.
Oh. Mr. Audu.
Yes, my lord.
You have heard Mr. Oji.
Yes, my lord.
Are you in receipt of the final address filed by the defendant?
Yes, my lord. And I'm very much aware that he filed the final thing address out of time.
Oh, God. Madam, come and help me.
So, my lord, it's important to check that the final address is proper. So, it has to be filed out of time. So that I can proceed for the business of today, my lord. That is our application, my lord.
What did you say?
My lord, I am applying to the Honorable Court that the final written address filed by the counsel for the defendants be struck out. Same has to be filed out of time so that we can proceed for the business of today, my lord. That is my humble application, my lord.
Do you want to rely on the final written address you had already filed?
Yes, my lord.
Mr. Oji. There is no way in the record of court whereby the court said you shouldn't pay, that you should file because you didn't file when you were supposed to have filed since last year. The court never said that you shouldn't pay default fees or you shouldn't file a motion to regularize. The court only urged you by putting you on your toes that you should do so within few days. That does not mean that you shouldn't pay for the default, which is on record.
My lord, I misinterpreted it myself, but I can still regularize.
So how do you want to regularize?
By paying the default fee, my lord, and then taking steps to regularize the position, my lord.
So move an oral application and then you pay the default fees.
Very well, my lord. My lord, my lord, we will subsequently pay the fees as assessed by the court. My lord, our humble prayer is that our final written address be admitted as properly filed, my lord.
Is that an application, oral application to regularize a motion?
Yes, my lord. My lord, we will subsequently pay the required fees, my lord.
I'm not saying you won't. I'm not saying you won't pay. But my question is that how to move an oral application for extension of time to file a process?
My lord, our prayer is for an extension of time to enable us to regularize ourselves, my lord. I don't.
Mr. Audu, any objection?
My lord, in the interest of fair hearing, I will not be objecting to his application. And I thank my lord especially for bailing Mr. Audu out of the situation he finds himself. Otherwise, I was fully armed with an application to strike out his process. Thank you very much for guiding him, my lord.
Order as praying time is extended for the defendants to file their final address. Same before the court are deemed properly filed and served. Defendants are to pay penalty within 72 hours and receipt of payment produced in court.
As God pleases.
Go ahead now and adopt your final address.
As the court please. My lord, the guided. I filed my final written address before the counsel for the defendant. So I don't know whether I'm the first to adopt or it should be the first to adopt.
Ordinarily, he is supposed to adopt because there was a trial.
Yes, my lord.
But since you go ahead.
Okay, thank you very much, my lord. My lord, before our final written address, we shall first of all proceed to...
Mr. Oji will adopt first. Mr. Oji will adopt first.
Thank you very much, my lord.
Go ahead.
My lord, before this honorable court is our final written address dated, sorry my lord, dated the 7th day of February 2024, filed and served on that same day. My Lord, that is our final position on this matter, and we have prayed the court accept it as our final address, my Lord. I so submit, my Lord.
Mr. Audu.
My Lord, before we adopt our final written address,
Mr. Oji,
we have
mute
a
your
humble
phone.
application to make.
Mr. Oji, mute your phone.
Sorry. Adams.
Mute your audio.
Come and help me.
Audu, go ahead.
Sorry.
Yes, my Lord.
Adams, come.
My Lord, our humble application is that the preliminary objection filed by the counsel for the defendant be struck out. Same haven't been abandoned. That is our humble application, my Lord. That the preliminary objection filed by the counsel for the defendant be struck out. Same haven't been abandoned. Thank you very well, my Lord.
Mr. Oji. Mr. Oji, what's your reaction to that?
My Lord, we consciously make reference to it in our issue 1. My Lord, in our argument, we raised 3 issues for determination. We made 3 issues, and in our issue 1, my Lord, we reiterated the position. We adopted all our arguments contained in the notice of criminal objection. On issue 1, my Lord, on whether in instituting the case, the claimant have complied with statutory for the judicial.
Very well. Unmute your audio. Unmute your audio. Unmute your audio.
Okay.
Unmute your audio. You said you have argued it in your issue 1.
Yes, issue 1, my Lord. We raised 3 issues on our issue 1 on whether the claimant have complied with statutory condition precedent. We raised this issue. We adopted on that issue.
You argued it.
We argued it in
Very
the preliminary
well.
objection.
So, Mr. Audu, did you react to that?
My Lord, I want to react on point of law orally, because the counsel for the defendant did told us at the last adjourned date that he was going to start in less than a day. And then my greatest...
Mr. Audu, I cannot take that oral submission down. I can't take it down in longhand. Not today. I will not do that. So if you intend to react to that, you can do so. I give you 2 hours to file. I said I cannot take down any oral submission in reply to a notice of preliminary objection in long hands. You had all the opportunity to react to it. So I cannot take. And the positive dealt with it, my written address is so why don't you adopt it?
No, I'm only saying that he raised the issue in his own final written address. That is what I want to do by the operation of just a minute.
I cannot write in long hands. I'm sorry.
My Lord, my adumbration is able to draw my Lord's attention to something. That what is saying. Hello, my Lord.
Then go ahead and move your application. Move the one that you want to move. adopt your final address. If you want to argue your counter to the notice of preliminary objection, go ahead and do it. But that the court should overlook a process before the court, I won't do that.
Oh, well taken, my lord. My lord, our counter affidavit in response to the notice of preliminary objection is dated the 3rd day of July 2023 and filed on the same day, my lord. My lord, the said counter affidavit is deposed to by Comrade Habib Usman, the first claimant respondent in the application. My lord, our counter affidavit is made up of 24 paragraphs.
Very well.
My lord, we rely on all the paragraphs of our affidavit, my lord. My lord, in support of our counter affidavit, we also filed a written address, my lord. My lord, our written address is dated the 3rd day of July and filed on the same day, my lord.
Very well.
My lord, we adopt the same written address. My lord, in reaction to the final written address filed by the counsel for the defendant, my lord, my lord, the claimant also filed their final written address. My lord, the claimant's final written address is dated the 26th day of July 2024 and filed on the same day, my lord. My lord, we adopt the same claimant's final written address, my lord. My lord, by the law of our country, we just to draw my attention to the fact that the public service rule and the guideline for appointment, promotion, and discipline are stated and submitted exhaustively by the counsel for the defendant are not the extant public service rules and guidelines for appointment, promotion, and discipline. My lord, the current public service rules, the extant public service rules, public service rules, corrected version 2008.
2008.
My lord. Why the extant guideline for promotion, for appointment, promotion, and discipline is guideline for promotion, for appointment, promotion, and discipline. Revised edition 2008.
I don't know.
We therefore, in the circumstance, urge my lord to discontinue with the old public service rules quoted by the counsel for the defendant, and for my lord to consider the extant public service rules and guidelines for appointment, promotion, and discipline in deciding the
Very well.
Thank you very much, my Lord. That is our humble submission. My Lord, sorry. Hello, my Lord. The guideline for promotion, appointment, and discipline, revised edition, is 2008, my Lord. I don't know whether it's 2008 or 2004. It's 2008. Both of them are 2008. The public service rules corrected version 2008, and then the guidelines for appointment, promotion, and discipline, revised version 2008, my Lord. These are the expert public service rules and guidelines for appointment, promotion, and discipline, my Lord. Thank you very much.
Let's adjourn to 9/5/2024 for judgment.
Thank
you very much, my Lord.
The court will rise.
Put it off now. Go and bring that file.
Put it up. We go like this. Okay. See, leave the